Well, one of the things that we're seeing, not just in eDiscovery, but also in litigation where parties engage experts. So it could be a medical expert or an engineering expert. In our case, it's digital forensics, or even eDiscovery, is the concept of joint appointment. So this is where instead of each party having their own set of experts, they agree to appoint one. So what that does is it massively reduces the time spent on the review, thus saving cost. So this year, for example, in Singapore, we were appointed on, I believe, 3, if not 4, and it's certainly a trend that we're seeing moving forward. What the courts do not want to see is an argument between experts, which will slow things down, especially prior to discovery or post-discovery, where there's a lot of correspondence between law firms and our expert said this, and then there's a reply, and so on and so on. So it just seems to drag on the matters. So they don't want to see that. Another thing which I haven't experienced yet is the concept of hot tubbing, where at trial you would put both experts together on the stand, and they would hopefully reach some common ground, so that the proceedings can continue, as opposed to having one expert on the stand being cross-examined and then the other expert comes along. But I haven't seen that yet. So really, the big trend for me is joint appointment. There are some challenges, obviously. Sometimes we hear from one party and not from the other, so we have to chase the other party. Obviously, law firms have multiple matters, ongoing matters. So we need to make sure that we communicate to both sets of lawyers, that everyone knows exactly what's going on. But what we found is that it does tend to reduce cost, especially with regards, the time spent in court, which is a cost to clients. There are less of those type of proceedings. It shortens the timeline from writ to trial. Also, from our perspective, we can provide better and more cost-effective pricing because we are getting more volume, we're getting instructions from both parties, and everything is put onto a single platform. So we have matters where we have to set up 2 different sites, one for the plaintiff, one for the defendants, and they conduct their review, and then later they're all merged. So we can provide some economies of scale, and thus provide cost saving to clients.